everybody, welcome back to my YouTube channel. My name is Rishabh and this is our revision lecture number 10 of entire MCQ oriented fast track batch of CA final SPOM, that is your corporate and economic laws. In this video we are going to cover the most dangerous and the important chapter, that is winding up. So please stay tuned till the end of the video and please do share this entire playlist to all of your friends, because I'm receiving a lot of very good positive responses from the students, from my friends, from the YouTube subscribers, saying that they cleared the examination with the minimal efforts. Therefore, it's a humble request to all of you, please share these videos, these entire playlist to all of your friends, and this entire PDF you can get in the Telegram channel, the link of which is given into the description. Please do join that channel. And now, without wasting much of time, let us begin. Before beginning with the chapter, let us understand what is the differentiation between the term winding up and the liquidation. So I would say the winding up term is the broader term, in which there is also liquidation up is a subpart of winding up term. So winding up is a broader term that includes liquidation, that means the closing down and shutting down of the business, whereas the term liquidation has been defined as the selling of the assets and setting up the company. Now, winding up includes winding up under the Companies Act 2013 and the liquidation under the IBC Act 2016. Now, what are the circumstances under which a company may be wound up by the tribunal? This is your section number 271. So, what are the circumstances under which a tribunal may order for winding up of a company? Where a company has passed a special resolution into the general meeting, where company has acted against the sovereignty and the integrity of the India, where application by the ROC or the central government has been made to the tribunal, wherein the business of the company is being conducted in a fraudulent manner, where company has defaulted in filing of financial statement and the annual return under section 92 and under section 137 respectively for consecutive 5 preceding years. You have to be very careful with these 5 years. That means you should be, there should be a default for 5 consecutive years, 5 consecutive previous years. In that case, only company can be wound up by the order of the tribunal. If tribunal deems it fit and it assumes that it is fair to wind up the company, in these 5 circumstances, a winding up order can be passed by the tribunal. This is what your section number 271 talks about. Section 270 talks about petition for the winding up. Here we learned under what circumstances tribunal may order for winding up, but 272 talks about who are the persons who can make the application for the winding up of the company. So petition can be filed by the company by way of passing of special resolution, as we learned in the last provision. Any contributory का definition we will understand over here, important points में, but any contributory can make an application for the winding up. ROC, registrar of the companies, can make, any person who is authorized by the central government and by state government or central government in case affairs of the company are being conducted in a fraudulent or affairs of the company are against the public interest. These 5 persons can make a petition for the winding up. Section 273 talks about tribunal upon receipt of application may within 90 days. Tribunal upon receipt of application from any of these 5 persons, as you can see over here, any of these 5 persons can make application to the tribunal for winding up of the company. Tribunal upon receiving of application from any of these 5 persons, it can dismiss the application, that means it can reject the application. It can pass an interim order. It can appoint provisional liquidator where company assumes that there is any kind of fraud being conducted. Then in such a case, a company may appoint a provisional liquidator. Tribunal may order for winding up of the company, and tribunal may pass any other order as may it deem fit within 90 days from the date when application is being made by any of these 5 persons mentioned under section 272. I hope this is clear. Now, what are the important points? Now, copy of petition shall also be filed with ROC, and ROC shall submit its view to the tribunal within 60 days of the receipt of petition. Now, whenever there is a petition is being filed for winding up of the company, then any of these 5 persons, whoever are mentioned over here, 1 minute, let me clear all this. Now, as you can see here, any of these 5 persons can make the application to the tribunal for winding up of the company. Once these 5 persons are filing application to the tribunal, they are also required to file the petition to the registrar of the company. The copy of the petition shall also be filed to the ROC, and ROC shall, upon receipt of the application from any of these 5 applicants, shall file its views to the to the tribunal within how many days? Within 60 days. So these timelines are very, very important from exam perspective. MCQ question was asked in my examination from this point. Point number 2 talks about contributory. Here we learned an application can be made by a contributory. But who is a contributory? A contributory means a person in whose name shares were held for at least 6 months during the preceding 18 months before commencement of the winding up. That means under your general members of the company are considered as a contributory. The term has been defined as contributory under winding up. So your members, which may be present or maybe the past members, are basically the contributory under your winding up. Right? Section 271 talks about upon receipt of application, the tribunal shall, before passing order under section 273, shall provide reasonable opportunity of being heard to the company within 30 days. That means the company should be provided with the reasonable opportunity of being heard before passing any order under section 273. It may pass any of these 5 orders, but before passing the order, company is to be given a reasonable opportunity of being heard. ROOBH means reasonable opportunity of being heard to be provided to the company, and company shall respond within 30 days from the date it has received a notice from the tribunal in order to represent their case before the tribunal. And additional 30 days can also be granted if there is a reasonable cause. If company does not respond within 30 days from the date of receipt of notice from the tribunal as a reasonable opportunity of being heard, then if no response is being submitted, then the right of the company to object will be forfeited by the tribunal, and there would be a penalty upon the officers, which may be an imprisonment for a period of 6 months, or fine, which may be 25,000 rupees to 5 lakh rupees of fine. Point number 6 talks about binding of petition admitted by the tribunal. Here we learn, before passing an order, tribunal is to be given, company is to be given an opportunity of being heard. But here we are saying that before binding a petition admitted by the tribunal. Now, once a company has admitted the tribunal, once the tribunal has admitted the binding of petition, then what is to be done by the tribunal? Now, where the binding of a petition is admitted by the tribunal, tribunal may appoint provisional liquidator in case any suspected fraud is suspected by the tribunal. Where tribunal assume that there is any kind of fraud being committed in the company, then in such a case, rather than passing and winding up order, tribunal will appoint a provisional liquidator. So the term PL, you have to be very careful, because we are going to assume this term. Please understand, PL stands for provisional liquidator, and we are going to use this term a lot of times in the subsequent part of this chapter. Now, there are 2 circumstances after once a winding of application is being admitted by the tribunal. Either it may appoint provisional liquidator where the company is having any kind of suspicion with respect to fraud, and apart from this, there may be a winding up order, and which can be ordered by the tribunal, where in case company is not having any kind of fraudulent activity being conducted. Now, upon winding the passing of appointment, upon passing of winding up order, company will appoint provisional company liquidator or the official liquidator, as the case may be. So the provisional liquidator would be appointed when there is a fraudulent circumstances going on in the company, and company liquidator or the official liquidator, either of them would be appointed in case tribunal is passing and winding up order. Now, PL, CL या फिर OL shall submit declaration of no conflict of interest within 7 days of such appointment by the tribunal. Tribunal will appoint either PL, CL या फिर OL, and they should submit a declaration to the tribunal within 7 days of their appointment with respect to any conflict of interest. If there any, they have to submit to the tribunal. Provisional liquidator may become company liquidator of the official liquidator in the subsequent parts. Point number 7 talks about removal, replacement of the liquidator. Under what circumstances a liquidator can be removed? Liquidator can be either provisional liquidator, official liquidator, or the company liquidator. He has conducted in misconduct, fraud or misfeasance. He has failed to exercise due care. There is an inability to act as PL, CL, or OL, and there is any conflict of interest. Under these circumstances, he may be removed or replaced by the tribunal. If any loss to the company due to any of these points, then tribunal may order for recovery from such person after providing a reasonable opportunity of being heard. Point number 8 talks about intimation to CL, PL, and ROC. Once, for appointment of PLCL to PLCL and ROC within 7 days of passing on order, tribunal will pass an order for winding up of the company and will appoint PL and CL. Now, after appointment of PL, CL या फिर OL, the tribunal shall intimate to PL, CL, OL along with the ROC within 7 days of their appointment. This is what this provision talks about. Point number 2 of this provision talks about winding up order is deemed to be a notice of discharge to the officer, employee, workman, except business which is to be continued till the liquidation. That means once winding up order is passed, that means this is a notice of discharge to the officers, employees and workmen, but the business would be continued until the liquidation is completed. Third provisions talk about CL shall within 3 weeks of order of winding up by the tribunal make application to the tribunal for the constitution of the winding up company. CL means company liquidator within 30 days, within 3 weeks of order of winding up by the tribunal shall make application to the tribunal for constitution of winding up company committee, and who would be the members? Official liquidator, nominee of record creditors and professional who is nominated by the tribunal. These are the persons who are part of your winding up committee. Now CL to be the convener, convener of the meeting committee. That means calling and preparing minutes of meeting. He would company liquidator would be responsible for doing all these activities. Point number 10 talks about where any winding up order has been passed by the tribunal, no legal suit, legal proceedings shall commence, or if there is any kind of existing legal suits or proceedings which are ongoing, then they shall not be continued without the permission of the tribunal. However, application for seeking leave, that means they can be continued, but after making an application to the tribunal, and the tribunal shall within 60 days upon receipt of the application shall either accept or reject the application. However, there is no requirement of the approval from the tribunal where the case is pending before the Supreme Court or maybe the High Court, as the case may be. Point number 11 talks about CL shall within 60 days of order of winding up shall submit its report with respect to assets, liabilities, capital, holding subsidiary, directors, creditors, all these reports to be submitted to the tribunal by the company liquidator within 60 days. Custody of company liquidator's property. All the properties of the company would be under the custody of the company liquidator, and it would be deemed to be under the custody of the tribunal. All promoters, directors, officer, employee of the company to cooperate with the company liquidator. Settlement of contributories. Upon winding up order, tribunal shall finalize the list of contributories. Any person shall continue to be liable as past contributory if company goes into liquidation, company goes into winding up within 1 year from the date on which he ceases to be a member, on which he ceases to be a contributory. Apart from this, these two conditions also to be fulfilled, and present members are unable to pay. Along with that, liability of the past members shall only be to the extent liability incurred by them up to the date of membership. So all the three conditions are to be fulfilled together by the contributories when a tribunal is going to ask money from the contributories. Now, point number 15 talks about directors of managers with unlimited liability shall be liable to make contributions as if he were a member of the unlimited company. Only with an unlimited liability. Whenever director or manager were having any limited liability, then this provision is not applicable. But this is to be applicable when winding up commence within 1 year of the cessation, liability only towards the liability incurred during their tenure, and liability only if tribunal deems it necessary. Under these three circumstances combined together, these three conditions should to be fulfilled, and then only their liability can be unlimited. Now 16 point talks about advisory committee. Maximum 12 members would be there, and the chairperson of the committee would be the company liquidator. These provisions are completely very completely focused from the perspective of MCQs. So from MCQ perspective, these are very helpful. If you like the video, please share this video to all your friends. This is a humble request. And now let us move ahead. Point number 17 talks about powers and duties of the company liquidator. Section 290 talks about powers and duties of the company liquidator. I would recommend you to refer ICE module, and I don't assume it to be a very important question from the exam perspective. Therefore, I have not covered this section over here. Company liquidator may appoint one or more CA, CS, CMA, legal practitioner, or maybe the registered valuer for any professional assistance. Company liquidator may either suo moto or upon request in writing by 1/10 in value of the creditors or the contributories summon their meeting to ascertain their wishes. So company liquidator either may suo moto or may be by an application by the contributories or the creditors in the value of 1/10. If any application made to the contributory, then the company liquidator can have their meetings to ascertain their wishes. Audit of company liquidator accounts. Company liquidator shall minimum twice a year submit reports, submit books and accounts to the tribunal in duplicate format. Duplicate copies to be submitted at least twice a year. Point number 21 talks about payment of debt by contributory and extent of set off. Matlab, a tribunal will ask money from the contributories where the present contributories are unable to contribute to the maximum. Then tribunal will ask the past contributories to make the payment, but their payment can the payment of them can be set up to not. This is what we are going to understand in this section. Now the tribunal may require contributories to pay money, outstanding money. Tribunal may, if in case of unlimited company and in case of limited company. In case of unlimited company, setup of liability is allowed except dividend and profit, whereas in case of a limited company, setup of liability is not allowed. That means if any contributory is having any kind of liability with the company, means the company has to pay any kind of amount to the contributory, and the contributory is going to pay from the order of the tribunal to the company. Then both of these can be set up if the company is unlisted, unlimited liability, unlimited company, and if it is an limited liability company, then in such a case set off is not allowed. Arrest of person who is trying to leave India or abscond. A tribunal may cause contributory to be detained for a period, whatever the tribunal may deem fit, or his books, papers, or any movable property to be seized and safely kept by the tribunal if any person who is going to abscond from the India or is leaving India for any purpose. Now, where affairs of the company are completely wound up, then company liquidator to make application to the tribunal for winding for the dissolution. Tribunal shall, upon order of dissolution within 30 days, forward copy of order to the ROC and direct company liquidator to forward the copy to the ROC, and ROC to make every entry in his register with respect to the dissolution of the company. Now we are going to understand the overriding preferential payments in case of a winding up. Now, overriding preferential payments from total debts, first to be paid to the workmen's due. Matlab, first and foremost, whenever you are going to wind up, then firstly payments are to be made to these two persons. First one is the workmen's due and the second one is the secured creditors, and it is to be paid proportionately. Workmen's due, which is outstanding for more than 2 years, are to be paid very firstly apart from any other payment, including their holiday remuneration, any kind of leave, travel concessions, or leave encashments are to be paid in preferential payment. Now, after payment under point number 24, preferential payments are to be made for the following persons: all government liabilities payable and due within 12 months immediately before the date. Revenue, taxes, cess, etc. are to be paid firstly. After that, all wages, salary for period not exceeding 4 months within the 12 months immediately preceding the relevant date. What is the relevant date we are going to understand over here, are to be paid after the point number 1. Now, point number 3 talks about due to the employees for their PF, ESIC, pension fund gratuity are to be paid after the above 2 payments. And point number 4 talks about expense of investigation under section 213 and 216 are to be paid after the above 3 payments. Now, what is the relevant date? Date of appointment of provisional liquidator in case there is any fraud being suspected into the company by the tribunal, or date of passing up or binding up of order by the tribunal in case there is no provisional liquidator is being appointed. That date is considered as a relevant date. Point number 26 talks about where company makes payment to the unsecured creditors before liquidation by way of fraudulent preference. Within prior 6 months of liquidation, tribunal may order for restoration of payment and treat that payment as invalid. Matlab, any kind of preferential payments made by the company to the unsecured creditors would be deemed to be void within previous 6 months from the date of liquidation, by the tribunal. Now, point number 27 talks about any transfer of property or delivery of goods within 1 year before presentation of winding up of order shall be void. Matlab, any transfer of property, any transfer of goods within 1 year, before the presentation of order of winding up shall be void unless the transfer is made in the ordinary course of business, along with that in favor of the purchaser in the good faith and for a valuable consideration. If all the 3 conditions are satisfied, then only this provision is not applicable. Otherwise, any transfer of property or goods are to be void within 1 year. If it is made within 1 year from the date of, if it is made within the preceding 1 year from the date of presentation of winding up order. Now, transfer by company of property to the trustee is completely void. That means if any kind of property is transferred by the company to the trustees in favor of the creditors or unsecured creditors, then that kind of transfer would be completely void. Point number 29 talks about floating charge created within 12 months before commencement of winding up. That means if solvency of company can be proved, then it is a completely valid transaction. But if solvency is not proved, then if a loan is given in consideration of a charge, then valid charge subject to interest rate of 5% per annum minimum, and no such loan should be given, then it should be a invalid charge. How will you determine whether a company is a solvent or not? Then they should be not default in any kind of repayment, and you can verify this by way of bank statement. Now, disclaimer of onerous property. Now let us understand what is the meaning of disclaimer and what is the meaning of onerous property. Disclaimer means extinguishments of any kind of right, any kind of asset. Onerous property means any kind of property that is having any kind of liability associated with it. So disclaimer of onerous property means extinguishment of certain rights or assets having liability attached to them. Now, where any part of property consists of land with tenure of onerous contract, shares, stock in any other company, properties which is not sellable, or any kind of unprofitable contracts, the company liquidator will leave to tribunal by writing at any time within 12 months after commencement of winding up with respect to disclaiming the property. Matlab, the company liquidator can disclaim any kind of these assets, any kind of these rights with the tribunal. It will leave with the tribunal by way of writing within 12 months after the commencement of winding up. Next point talks about if company liquidator is not aware of any such rights or assets. Matlab, any of these rights were present in the company, but the company liquidator was not aware with respect to any kind of these rights or the live assets. Then, and he comes to know later on, then if he comes to know within 1 month from the commencement of winding up, then in such a case he can disclaim within 12 months from the date of commencement of the winding up. But in case he comes to know any kind of assets or the rights which are kind of onerous contracts, then in such a case after 1 month he comes to know any kind of onerous property, then he can disclaim within 12 months from the date of knowing the fact. Matlab, after 1 month he got to know that there are any kind of assets, there are any kind of rights which are onerous rights, then he can disclaim those rights. If he got to know after 1 month, with he can disclaim such rights within 1 year from the date when he got to know about such rights. Point number 31 talks about transfer of shares in a company, disposition of property including actionable claims, and alteration in the status of the member after commencement of winding up shall be void. But any kind of these three transactions, if are conducted after the commencement of winding up order, then these are to be completely void under your Companies Act. Any attachment or execution put in force, any sale held without the leave of the tribunal shall be void. Matlab, you are kind of attaching or executing any kind of force, or any sale is being conducted without the leave, without the permission of the tribunal, then shall be void. Offences by the officers of the company in liquidation. If you read all these offences, you will be able to easily remember this. Please be very careful with respect to this particular timeline. Now, penalty would be not less than 3 years to 5 years, fine, imprisonment, and fine would be 1 lakh to 3 lakh. I think these, if you read your own, you will be able to easily understand. Now, company liquidator dividend and undistributed asset account. When company is being wound up and liquidation in his hands, money representing, company is being wound up and any kind of money in his hand representing any kind of dividend which is payable to the creditors, which is unpaid for a period of 6 months, and any kind of asset that is refundable to the shareholders, to the contributors, undistributed for a period of 6 months, then these are to be transferred to the company liquidation dividend and undistributed asset account. Any person can claim from ROC, any of these two can be claimed by any person from ROC, and registrar shall settle the claim within 60 days of date of making an application by such person. If after 15 years they are unclaimed, if once they are submitted, any kind of money which is lying in which is being unpaid for a period of 6 months, these two monies if are being unclaimed for a period of 6 months, then these are to be transferred to this particular account. This is basically your company liquidation and dividend and distribution asset account. If it lies there for 15 years and remains unclaimed, then it is to be transferred to general revenue account of the central government. If liquidator fails to pay money to any of these accounts, then interest to be paid at the rate of 12% per annum by the liquidator. Now, company liquidator who made any default in filing, delivering, returning accounts or other documents, or in giving notice which is required by the law, then company liquidator shall make go to the default within 14 days upon service of notice to him by the tribunal to do so. Now, a tribunal on application of company, liquidator or any interested person within 2 years from the date of dissolution may pass order to declare dissolution as void. Matlab any order of dissolution was passed by the tribunal, but the tribunal may on application of the company liquidator or any other interested person within 2 years from the date of dissolution can declare such an order as void. Tribunal shall forward copy of order to the ROC within 30 days and also direct company liquidator persons on whom application it was dissolved to file order to ROC within 30 days. If he fails to do so, and then there would be a penalty of rupees 10,000 rupees per day. Winding up of company by tribunal deemed to commence at time of presentation of petition of winding up. The next point is very easy to understand. That's all about your entire winding up chapter. If you like the video, please share to all of your friends and do let me know in the comment section how you like the quality of this content. Thanks a lot for watching. Thank you so much.